The witnesses who would have given favorable testimony about Baldwin, again, it doesn't matter if it's not relevant favorable testimony, were kept from the grand jury. Every favorable or exculpatory document was concealed or only partially presented. Again, it doesn't matter if they were irrelevant to the criminal charge. Every favorable fact was hidden. Only matters if it's a fact relevant to the criminal charge. And all of the grand jury's inquiries about exculpatory information were redirected to witnesses who misrepresented the facts or had no foundation for giving the answers. The exculpatory information only matters if it's relevant to the criminal charge. The state had one goal. Yeah, they had one goal. Indict Baldwin, no matter the truth. What? No matter the rules or court rulings, and no matter what it took to do so. If the state's conduct here does not demonstrate the level of bad faith necessary to subject an indictment to judicial review, it is all but impossible to imagine a set of facts that would. This is all just theater talk. 2, the indictment must be dismissed. Under New Mexico law, the grand jury is our system's foundation for the protection of individual rights and a recognized method by which the public can be certain of protection against abuse of public responsibilities. But the grand jury method cannot function when prosecutors conflate their role as an aid to the grand jury with the role of the grand jury itself. I'm going to skip all the internal little paragraph quotes here. That is exactly what happened here. The state deprived the grand jury of its ability to accurately and independently assess the government's evidence of probable cause and instead used the grand jury as a private tool to obtain Baldwin's indictment. The grand jury had everything they needed. Everything that the defense offered. They could have subpoenaed every witness. They could have gone through the box of supposedly exculpatory evidence. It was all given to them and pointed out to them what this was. The indictment must be dismissed for 2 independent reasons. First, the state unlawfully deprived the grand jury of critical evidence. Notice it doesn't say relevant evidence. Critical evidence that disproves the charges or makes an indictment unjustified. See, they combine these two. See the trick here? It's wrong if it either disproves the charges or makes an indictment unjustified. Disproves the charges would mean it negates one of the elements. None of this evidence does that. But does it make an indictment unjustified? Well, unjustified is just a subjective judgment call, right? The defense thinks it's unjustified. And second, the state conducted the grand jury process in an unlawful manner, including by providing an improper charging instruction regarding a critical element of the offense. Nah, that's not what happened. We just went over that. A, the state unlawfully deprived the grand jury of exculpatory evidence. They always leave out relevant. Exculpatory evidence and evidence that was favorable to Baldwin's position. Again, that's like bringing in Alex's mother. Continuing, unless the grand jury is empowered to consider all lawful, relevant, and competent evidence bearing on the issue of probable cause, the grand jury cannot perform its historical role of determining whether those accused of wrongdoing by the government should suffer the burdens of a criminal prosecution. Thus, the state was required to facilitate the grand jury's inquiry into any lawful, relevant. Notice every time the defense is quoting actual case law, what does the case law say? Does it say lawful, competent evidence? Does it say lawful, favorable evidence? Does it say exculpatory, favorable evidence? Or does it always include the word relevant? Thus, the state was required to, quote, facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence not initially presented by the state that would disprove or reduce the charges. That's what I've been saying, right? Disprove or reduce the charges. It would tend to negate one of the elements of the criminal charge. That's what makes it relevant. That would disprove or reduce the charges against Baldwin or make an indictment unjustified. Morrissey's intentional violation of that duty, no, and withholding of potentially exculpatory evidence strikes at the very heart of the grand jury's assessment of probable cause to indict. The indictment must be dismissed because the state withheld exculpatory and favorable evidence. What's missing here? The word relevant. As described above, excuse me, folks. As described above, Baldwin's alert letter describes piles of documents and more than a half dozen witnesses who had information favorable to his defense. Missing again is the word relevant. There are witnesses who saw Baldwin's conduct in set, and it said he handled guns safely. Was he handling it safely when he killed Helena Hutchins? Because that's the only relevant question here. A witness who said that he, not Baldwin, was responsible for checking the firearm and that Baldwin was not at fault. That would be David Halls. What does he have to do with Baldwin pointing the gun at Helena Hutchins, cocking the hammer, and pressing the trigger? There are documents corroborating Baldwin's statements that he had no control over the production of the movie, other than the right to give limited creative input about co-stars and script. Baldwin's role as a producer is irrelevant to this manslaughter charge. He's not being charged under some kind of agency principle where it was not him, it was some other actor handling the gun, but he's nevertheless criminally responsible because he had authority on the set. That's not why he's being prosecuted. So it doesn't matter what his role as a producer was. If anything, it makes things worse for him because he was the guy with ultimate authority on the set. No one was going to question if he wanted the gun checked for live rounds in front of him. So it certainly doesn't help him, but that's not an element of the criminal charge against him. So again, it's irrelevant. Guidelines and industry statements that make clear Baldwin had no obligation to check the gun. Industry statements is that press release by SAG. All their existing safety rules prior to the shooting put the responsibility for safety on everybody, including and explicitly the actor. There are also documents and testimony showing that the set was safe. Well, see how vague this is? How passive voice? The set was safe. That's not the legal question, is it? The legal question is, was Alec Baldwin safe, acting with due care and circumspection when he pointed that gun at Helena Hutchins, cocked the hammer, pressed the trigger, fired a live round, and killed her? The list of favorable evidence goes on and on and on. But is it relevant favorable evidence? That's the legal